Welcome everybody to the Harry and Jane Scheiber lecture for 2024. I'm thrilled that we have Professor Bernard Oxman here today. I'm going to turn it over to Professor Holly Doremus to introduce Professor Oxman. Holly is our faculty director of the Law of the Sea Institute here at Berkeley, where she has been working on a number of seminal papers with other members of the Law of the Sea Institute and colleagues from the Korean Institute of Science and on Ocean Science and Technology. As many of you know, Holly has an interdisciplinary background spanning science and law, so brings special expertise and perspectives to this work. With that, I will turn it over to Holly.
Well, it's my great pleasure to introduce this talk and to introduce our speaker. First of all, about this lecture series, Harry Scheiber, for any of you here and on the live stream who don't know Harry, he's the Stephen A. Riesenfeld Professor of Law and History Emeritus and Chancellor's Emeritus Professor here at Berkeley, and the longtime director and co-director with David Karen of the Law of the Sea Institute, which he brought here to Berkeley. The Harry and Jane Scheiber Lecture in Ocean Law and Policy recognizes the very influential scholarship of Harry Scheiber in ocean law, history, and policy, and recognizes Harry and Jane Scheiber's joint contributions to advancing the subject through the Law of the Sea Institute's conferences and publications. We're very grateful to Harry for all he's done for the Law of the Sea Institute here and for Berkeley. Our speaker today is Bernard Oxman. He's the Richard Hausler Professor of Law at the University of Miami, where he teaches, among other things, international law and law of the sea, and he directs the law school's LL.M program in maritime law. He's been a visiting professor here at Berkeley, in Paris, and at Stanford. He's a member of the Institut de Droit International, the American Law Institute, and the Council on Foreign Relations. After receiving his JD degree from Columbia Law School, he served on active duty in the International Law Division of the Office of the Judge Advocate General of the Navy. Then he was the first assistant legal advisor for oceans, environment, and scientific affairs at the U.S. Department of State. And he was the U.S. representative to the Third United Nations Conference on the Law of the Sea and chair of the English language group of the conference drafting committee. Professor Oxman is the only American to have been appointed as a judge ad hoc of both the International Court of Justice and the International Tribunal for the Law of the Sea, where he's been 3 times appointed as an ad hoc judge. And he has served as an arbitrator and counsel in a number of international cases. He's been co-editor-in-chief of the American Journal of International Law, vice president of the American Society of International Law. He has a list of awards that's much too long to go into here, but I did want to call out perhaps most recently notably, he's a recipient of the American Society of International Law's highest honor, the Hudson Medal. And we are incredibly lucky to welcome him here to Berkeley. His topic is going to be a lawyer's first impression of the new High Seas Biodiversity Treaty. Thank you so much for being with us, Professor Oxman.
Thank you very much, Professor, for that very kind but unfortunately undeserved introduction. It's a very great pleasure to be afforded this opportunity to return to Berkeley after too many years, and a very great honor to be asked to deliver the Harry and Jane Scheiber Lecture in Ocean Law and Policy. It's also very humbling. The title of the lecture series invites us to contemplate Harry Scheiber's remarkable contributions to the field, and also to contemplate Harry and Jane's devotion to the protection of marine life and the marine environment. And the history of this lecture series already invites us to contemplate the extraordinary distinction of all of my predecessors, which include both the current chair of the International Law Commission, established by the United Nations General Assembly, and the immediate past president of the International Court of Justice, the principal judicial organ of the United Nations. The topic I selected is the new global treaty that, after almost 2 decades of work, was essentially completed almost exactly 1 year ago. And that was also almost exactly 1 year after Jane Scheiber left us. And we honor her memory here today. In many respects, I am the very last person you would expect to speak to you about this new agreement. Unlike many who have written and spoken about it, I did not participate in its preparation, apart from a very few conversations with some participants. And unlike many who have written and spoken about the agreement, I come to the topic from the perspective of oceans law and policy rather than environmental law and policy. Now, of course, neither of these perspectives excludes or could exclude the other. But as those in the arts, including the art of law, know full well, the angle from which something is viewed does indeed matter. I'm therefore particularly indebted to one of the most highly regarded experts in international environmental law, Professor Daniel Bedansky, who very graciously shared with me a draft of his forthcoming essay on the agreement in the American Journal of International Law, to which I commend you, and also to my joint JD PhD student at Miami, Gabriella Berman, who earned a master's degree in deep seabed marine biology at Scripps and is working on a research paper regarding the new agreement, on which I have the privilege of being her faculty advisor. The UN website is a very rich source of texts, documents, and information regarding both the new agreement and the UN Convention on the Law of the Sea and its 2 implementation agreements. Descriptions and analyses of the new agreement are also very easily found online, and I might add, in the library full of books. With only very limited time available here, I decided not to try to duplicate that material, right? But rather to proceed directly to explain some of my initial reactions to the new agreement after a brief and necessarily incomplete description of the agreement's contents. And I think, as will become clear as I speak, my concerns arise from certain legal issues and not from the agreement's environmental objectives. The text of the agreement was adopted last June by consensus. And I thought you might be interested to know that a longtime legal counsel at the United Nations, the late Konstantin Stavropoulos, once observed that consensus is a procedure where objections are stated, but they're stated after the gavel comes down. And we might discern something of the sort in the statements that were made at the conclusion of the negotiation of this new agreement, which include candid criticism by the Russian Federation, a long list of interpretations proffered by the United States, and many congratulatory statements that take the opportunity to stake out national positions. The UN website indicates that there are now 88 signatories of the new agreement. That includes the United States, and it also identifies what it calls 2 parties, Palau and Chile. The reference to parties highlights the fact that signature of the agreement does not constitute consent to be bound. but the reference should not be misunderstood to imply that the agreement is already in force. The agreement provides that it will enter into force only after the deposit of the 60th instrument of ratification or approval, acceptance, or accession. And that can take some time. It did indeed take quite a bit of time in the case of the Law of the Sea Convention itself. Let's consider for a moment the agreement's official title. And here I'll read it. Agreement under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. It took me more than one breath to do that. Some people for short call it the BBNJ Treaty. But I have to confess here that one of the less consequential consequences of my service in the Navy is an aversion to acronyms. So I prefer something like the High Seas Biodiversity Agreement, or for short, the new agreement. And that agreement addresses 4 different topics with respect to areas beyond national jurisdiction. Part 2 deals with marine genetic resources. It focuses on public dissemination of information through a clearinghouse mechanism, equitable sharing of benefits with developing countries, and the transfer of marine technology to those countries. Article 11, which appears in Part 2, specifies that activities with respect to marine genetic resources and digital sequence information on marine genetic resources may be carried out by all parties to the agreement and by natural or juridical persons under the jurisdiction of those parties. Now, this reference to parties to the agreement highlights the question of the rights and duties of non-parties to the agreement that may arise under the Law of the Sea Convention and customary international law. And that in turn may in part explain why there was so much controversy over including a reference to the common heritage principle in the new agreement. And it may also in part explain the United States statement of interpretation that the principle applies only to the seabed beyond national jurisdiction, as in the Law of the Sea Convention. Part 3 of the agreement deals with area-based management tools, including marine protected areas. Now, a fair number of international and regional organizations currently use area-based management tools in order to protect marine life and the marine environment in particular areas. And the benefits of doing so are not limited just to those areas. The difficulty is that each organization's competence is limited to particular activities or to particular regions or both. A significant function of Part 3 is to promote rational coordination and to help fill gaps in such a system. And some observers see these provisions of Part 3 as a vehicle for implementing the goal of protecting 30% of the planet's land and marine areas by 2030 that was set at the 2022 UN Biodiversity Conference, referred to as COP15. And indeed, some of you may have heard the reference to that goal in the President's State of the Union address last week. Part 4 of the agreement deals with environmental impact assessments. It concentrates on adding very significant detail to the requirements for states to make such assessments that is set forth in the Law of the Sea Convention. It makes the process more transparent and public and affords other states and the scientific technical body established by the agreement the opportunity to comment This part also establishes separate thresholds for screening and for full environmental impact assessments. Part 5 of the agreement deals with capacity building and the transfer of marine technology. The main objective of this part is to enhance the capacity to participate in conservation and sustainable use of marine biological diversity by developing countries. Parties are required to cooperate in such efforts and to provide resources within their capabilities to support these efforts. As an aside, in preparing for a lecture of this sort, one may come across fascinating bits of information that would otherwise escape one's attention. And I thought I might share one of these with you. In its official statement in connection with the adoption of the text of the new agreement, Turkey referred to itself as, and I quote, an upper middle income developing country. And of course, it's possible that Turkey is thereby positioning itself on the recipient side of the transfer technology. One of the virtues of the official title of the agreement that I read to you is that it signals its pedigree. The project drew its initial impetus from the Biodiversity Convention, a major international environmental treaty. And informed the agreement has much in common with international environmental agreements. This doubtless reflects the background of many governmental and non-governmental participants in the process. In addition, some of the agreement's most significant objectives with respect to genetic resources were inspired by the Biodiversity Convention's Nagoya Protocol. That protocol addresses genetic resources from areas that are within national jurisdiction, but not those that are beyond national jurisdiction. As the official title of the new agreement also suggests, in substance, the focus shifted to the United Nations Convention on the Law of the Sea. That convention was called a Constitution for the Oceans by Ambassador Tommy Koh of Singapore at the time of its adoption in 1982, and the appellation has indeed stuck. Some commentators now refer to the new agreement we're talking about here as the Law of the Sea Convention's third implementation agreement. And interestingly, that is how the European Union apparently envisaged the project at a quite early stage. The extent of the shift in focus in the negotiation of the new agreement is suggested by its very first article. Like the two preceding implementation agreements, it defines the word convention with nothing further to mean the United Nations Convention on the Law of the Sea. I will do the same. The substantive import of this shift is made clear almost immediately. Article 5 of the new agreement provides, and let me quote it, "This agreement shall be interpreted and applied in the context of and in a manner consistent with the convention," unquote. This language is copied from Article 4 of the convention's 1995 implementation agreement on fish stocks. Now, we should contrast this provision that I just read to you with the very markedly different language of the convention's first implementation agreement in 1994. The object of the 1994 implementation agreement was to modify Part 11 of the convention dealing with deep seabed mining, and thereby render politically feasible the very widespread and representative ratification of the convention in all regions that ultimately occurred. Unlike Article 5 of the new agreement, Article 1 of the 1994 agreement says exactly the opposite. Namely, and I quote, "The states parties to this agreement undertake to implement Part 11 of the convention in accordance with this agreement, unquote. Article 2 of the 1994 agreement goes on to specify, and I quote, in the event of any inconsistency between this agreement and Part 11, the provisions of this agreement shall prevail, unquote. Now, I think it should be evident from the express text of the new agreement we are discussing today, and from the textual history that I briefly indicated to you, that the so-called later in time maxim does not determine the relationship between the new agreement and the convention. In principle, the formal geographic object of all three agreements, namely the 1994 and 1995 implementation agreements, and now this new agreement, is the area beyond national jurisdiction. This is a significant limitation that I think we all should bear in mind. By excluding the territorial sea and the continental shelf, we effectively exclude all or almost all significant hydrocarbon deposits, as well as many mineral deposits and significant marine life. By excluding the territorial sea and the exclusive economic zone, we effectively exclude much marine life and most, although by no means all, commercial marine fisheries. That said, it should be understood that the 1994 and 1995 implementation agreements, as well as the new agreement, have some impact in fact, and in a few cases, even in text, on environmental, economic, and other interests with respect to land and maritime areas that are within national jurisdiction. There are many reasons for this, and let me, in the time available, mention just two. First, the so-called father of international law, Grotius, pointed out that the vagrant waters of the sea cannot be enclosed. More generally, living organisms, the ecosystems that support them, and pollutants introduced by human activity traverse political and legal boundaries. In fact, we should not find it surprising that the effort to protect migratory birds provided the occasion for Justice Oliver Wendell Holmes, writing for the U.S. Supreme Court, to consider the constitutional basis for the implementation by Congress of the 1916 Migratory Bird Treaty between the United States and the United Kingdom in respect of Canada. Second, both the absence of economically significant restraints on activities beyond the limits of national jurisdiction and the imposition of such constraints may have an economic effect on the interests of consumers and on the interests of those who conduct the same activities elsewhere, namely on land or in marine areas within national jurisdiction. In some cases, that effect may in turn implicate strategic interests. Such concerns are evident, for example, in the doubts expressed by various officials about dependence for strategic goods on sources that are subject to manipulation by an unfriendly foreign power. Now, with these caveats behind us, we can then ask the question, where is the area beyond national jurisdiction? Now, to begin with, it depends on what one means by national jurisdiction. No part of this planet is beyond the reach of national jurisdiction. Under international law, individuals, corporations, and ships are subject to the exclusive or concurrent jurisdiction of their state of nationality, wherever they be. And by the way, if you don't believe me, just ask the Internal Revenue Service. But that is not a very helpful observation if what we're trying to do is identify a geographic area that is beyond national jurisdiction. So let's decide, first of all, that the term as used in the agreement relates to the sea, not to naturally formed land areas and not to their lakes and rivers. The Antarctic continent is not part of the sea. Neither is the smallest naturally formed rock that emerges above high tide. And neither are the Great Lakes and the St. Lawrence River. Under the Law of the Sea Convention, the sovereignty of a state extends seaward from its coast up to the limits of the territorial sea, which may not exceed 12 nautical miles from the coastal baselines. Beyond the territorial sea, there are two zones of coastal state sovereign rights for limited purposes, mainly exploration and exploitation of natural resources. The older of the two regimes concerns the seabed and subsoil, that is the regime of the continental shelf. The newer of the two concerns both the seabed and subsoil and the superadjacent waters. That is the regime of the exclusive economic zone. Both regimes extend seaward from the territorial sea limit up to a limit of 200 nautical miles from the coastal baselines. However, the regime of the continental shelf may extend beyond the 200-mile limit where the continental margin extends beyond that limit. And as some of you may know, the United States, which has the world's second largest exclusive economic zone, recently identified about 1 million square kilometers of continental shelf extending beyond 200 miles from its coast and up to limits that the United States determined in conformity with the scientific, geographic, and technical rules set forth in Article 76 of the Convention. I might add here that the United States in that case adhered to precisely all of the technical rules that the government of Colombia challenged as declaratory of customary international law in what I had once characterized as an audacious move before the International Court of Justice. The court managed to resolve the case without ever passing on Colombia's arguments. Colombia, by the way, is the only state that is not party to the Law of the Sea Convention that challenged its status as declaratory of customary international law. The United States has not done so. It's done the opposite. And Peru did not do so. In its case with Chile, it did the opposite. If we are speaking about the seabed and subsoil, the convention itself defines the area beyond the limits of national jurisdiction, which are really the limits of the continental shelf, which it denotes the area with an uppercase A at the outset. If we're speaking about the water column, however, and this point I need to stress, the Law of the Sea Convention contains no comparable geographic definition of a particular word or term. Specifically, unlike the 1958 Convention on the High Seas, the 1982 Convention on the Law of the Sea deliberately contains no geographic definition of the term high seas. Article 86 of the Law of the Sea Convention provides that the regime of the high seas applies to the area beyond the seaward limit of the exclusive economic zone, but it also specifies that it does not entail any abridgment of the freedoms enjoyed by all states in the exclusive economic zone in accordance with Article 58. So let's take a look at Article 58. Article 58, paragraph 1 preserves in the exclusive economic zone certain of the high seas freedoms listed in Article 87, the very first substantive article of the high seas regime. Article 58, paragraph 1 expressly refers to Article 87 in this context. The high seas freedoms listed in Article 87 that are expressly referred to by Article 58, paragraph 1 are the freedoms of navigation, overflight, and the laying and maintenance of submarine cables and pipelines. With the singular exception of provisions relating only to living resources, Article 58, paragraph 2 then incorporates by reference all of the remaining provisions of the high seas regime set forth in the convention, insofar as they are not incompatible with the provisions specifically applicable to the exclusive economic zone. The result is that if we are discussing fishing or marine scientific research or the exploration and exploitation of genetic resources, the regime of the high seas does not apply within the exclusive economic zone. But if we are discussing navigation, overflight, the laying and maintenance of submarine cable or pipelines, or such matters as hot pursuit, or the suppression of piracy or slavery, the high seas regime does apply within the exclusive economic zone. The 1985 Implementation Agreement on Fish Stocks refers to areas within and areas beyond national jurisdiction without defining those terms. It relies instead on the substantive provisions of the convention for that purpose. While it does distinguish between fishing on the high seas and fishing within areas of national jurisdiction, in the context of fishing, that is completely understandable. There is no freedom of fishing within the exclusive economic zone. Like the 1985 Implementation Agreement, the new agreement did not need a definition of areas beyond national jurisdiction. Even if a definition were considered desirable, it would have been a very easy matter to define areas beyond national jurisdiction for purposes of the new agreement without using the term high seas in a geographic sense. Very easy to do. Any first-year law student would do. Instead, Article 1 states, areas beyond national jurisdiction means the high seas and the area with a capital A. In doing this, the new agreement either leaves open the question of its application to high seas freedoms within the exclusive economic zone, or it does precisely what the convention intentionally did not do, namely define the high seas geographically as the area beyond the exclusive economic zone. Now, among the many undesirable effects, the latter understanding could conceivably reopen what appeared to be a question settled by Article 58 of the Convention, namely that the exclusive economic zone is included in important references to the high seas in the very widely ratified 1944 Chicago Convention on International Civil Aviation, and is excluded from its equally important references to territorial waters. Even if one were to retreat to the position that the definition is relevant only for purposes of the new agreement, and even if aviation were not regarded as coming within the scope of the new agreement to any significant degree, if at all, there is little doubt that navigation and the laying and maintenance of submarine cables and pipelines might be among the objects of some of the provisions of the new agreement regarding environmental impact assessments or area-based management tools. If we conclude that those provisions do not apply to navigation or submarine cables within the exclusive economic zone because of the reference to the high seas, we could be taking a wholly unnecessary step toward undermining one of the most important balances in the Law of the Sea Convention, which is the substantive balance between the rights of the coastal state and the freedoms of all states in the exclusive economic zone. Now, this is not the only place where securing respect for geographic and substantive limits on coastal state jurisdictional claims, which is one of the major objectives of the Law of the Sea Convention, does not appear to have influenced the negotiation of the new agreement. Article 6 of the new agreement provides that the agreement and measures taken thereunder shall not be relied upon as a basis for asserting or denying any claims to sovereignty, sovereign rights, or jurisdiction, including in respect of any disputes relating thereto. With the clarification that it relates to claims over land or maritime areas, that very language is repeated in Article 60 of the agreement, which is the basic article incorporating the provisions of the Law of the Sea Convention on compulsory settlement of disputes. Now, insofar as the exclusion relates to disputed claims to land territory, including islands, it would appear to be consistent with the interpretation of the dispute settlement provisions of the convention in a number of decided cases. But insofar as the exclusion relates to disputed claims of sovereignty, sovereign rights, or jurisdiction over maritime areas, the language directly contradicts, or at least appears to directly contradict, the Law of the Sea Convention on an issue that was at the very heart of the decision to include compulsory dispute settlement procedures in the Law of the Sea Convention in the first place. Now, it can be argued that it is the Law of the Sea Convention rather than the new agreement that addresses these issues, and accordingly, that any dispute settlement obligations with respect to those matters should arise from the convention itself. That's fine if we're dealing with parties that are parties both to the agreement and to the Law of the Sea Convention, because they would be subject to dispute settlement provisions under the Law of the Sea Convention. But the new agreement, like the 1995 implementation agreement, permits states that are not party to the Law of the Sea Convention to be party to the agreement. These states are apparently afforded the inexplicable privilege of avoiding obligations under the agreement simply because they have asserted claims to the maritime area in question. Now, the law of treaties might subject any such assertion to a requirement of good faith, but I suspect that the lawyers that were advising non-parties to the convention, such as Colombia and Turkey, that prefer to avoid or limit any obligation to arbitrate or adjudicate disputes, that those lawyers were presumably well aware of the fact that the arbitral tribunal in the South China Sea arbitration did find that China's claims were inconsistent with the Law of the Sea Convention, but it did not find that China's claims had been made in bad faith. For their part, China's lawyers were presumably well aware of the arguments that China had advanced in support of its assertion that the arbitral tribunal in the South China Sea case lacked jurisdiction. In this connection, we might look at paragraph 8 of Article 60 of the new agreement. It states, and I will read it, "The provisions of this article shall be without prejudice to the procedures on the settlement of disputes to which parties have agreed as participants in a relevant legal instrument or framework, or as members of a relevant global, regional, sub-regional, or sectoral body concerning the interpretation or application of such instruments and frameworks, right? Unquote. Now, it's a mouthful. What if the procedures for settlement of disputes in the other instrument or framework do not provide for binding arbitration or adjudication at the request of either party to the dispute? What happens then? What do the words "without prejudice" mean in this context to narrow the issue down to two words? Those who have followed the history of cases under the dispute settlement provisions of the Law of the Sea Convention might well wonder whether paragraph 8 reflects an attempt to revive the first arbitral award under the Law of the Sea Convention's dispute settlement procedures. That was the decision of the arbitral tribunal in the Southern Bluefin tuna case, that it lacked jurisdiction under the Law of the Sea Convention because the same dispute arose under a regional fisheries agreement that did not provide for compulsory arbitration or adjudication. The arbitral award in that case itself all but acknowledges that it is in tension with the express provisions of the 1995 implementation agreement regarding fish stocks, which provide exactly to the contrary, but that agreement was, of course, not then in force between the parties before the tribunal. The Southern Bluefin Tuna Award was widely criticized in environmental and conservation circles. It was invoked by China in the South China Sea arbitration, but it was not followed in that case or in other cases. A possible response to concerns about this problem is that paragraph 8 of the new agreement expressly provides that, quote, "Nothing in this paragraph shall be interpreted as limiting the jurisdiction of a court or tribunal under Part 15, Section 2 of the Convention, the Law of the Sea Convention." And that would appear to minimize the risk of upsetting the existing jurisprudence. But that does not avoid the risk in the new agreement itself, and it does not avoid the risk that paragraph 8 may be replicated in the future in other agreements. And it does not avoid the risk that limitations in other provisions of the agreement that lack the same qualification, such as the limitation with respect to maritime claims in the very next paragraph that we already talked about, will induce greater caution, even in cases brought under the Law of the Sea Convention itself. In addition, it certainly doesn't resolve the complexity that may arise when compliance with both the convention and the new agreement is at issue in the same case. And that, of course, would be a classic law school examination. Even from the specific perspective of environmental protection, the dispute settlement provisions of the new agreement fall short of what one might have expected. Let me elaborate. Litigation takes time. If a dispute is submitted to arbitration, the arbitral tribunal needs to be constituted. If the dispute is submitted to a standing court or a tribunal, there may be scheduling issues regarding other cases. Whatever the forum, the parties need to prepare their written and oral arguments and to respond to each other. The members of the court or tribunal need to study the materials, to hear the parties, to think about the issues, and to deliberate. Then they need to prepare a reasoned opinion. What exactly happens in the interim? It can take a long time, several years in much state to state litigation or arbitration. The statute of the International Court of Justice provides that the court shall have the power to indicate, if it considers the circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. And as you probably guessed or know, urgency is a basic characteristic of situations in which a court might exercise this power. The Law of the Sea Convention, which contains elaborate normative provisions on protection and preservation of the marine environment, takes this a step further. Article 290 specifies that provisional measures may be prescribed by a court or tribunal not only to protect the respective rights of the parties, but also to prevent serious harm to the marine environment pending the final decision. It also specifies that the International Tribunal for the Law of the Sea may prescribe such measures pending the constitution of an arbitral tribunal to which the dispute has been submitted. The 1995 implementation agreement on the fish stocks takes the even further step, both substantively and procedurally. Provisional measures may be prescribed by a court or tribunal to preserve the respective rights of the parties, but also to prevent damage to the stocks in question. In this connection, if the states concerned cannot reach agreement on conservation and management measures, and they are also unable to agree on provisional arrangements, then any of the states concerned may submit the dispute to a court or tribunal for the purpose of obtaining provisional measures. Now, it should be obvious from this background that provisional measures can play an important role in providing urgently needed protection for marine life and for the marine environment. This occurs, by the way, not only when courts and tribunals are actually asked to prescribe provisional measures. In order to minimize the risk that another state may seek such provisional measures, right, in order to minimize that risk, and in order to strengthen their argument if it happens that such measures are unnecessary, right, governments may be encouraged by their lawyers to take action to deal with urgent problems in a timely manner themselves. Now, I'll keep you out of court, but you've got to do the following things if you want that to work. In this connection, we might recall that Judge Tulio Travis, who was one of my distinguished predecessors in this lecture series, famously compared the object of the precautionary principle with the object of provisional measures. And you can look at this from a purely linguistic perspective. The relationship is much more obvious in French, where the legal term for provisional measures is mesures conservatoires, or in Italian, where the legal term is misure cautelari. Both those terms in French and Italian unquestionably suggest precaution. It's therefore surprising that Article 61 of the new agreement has only one sentence on provisional measures, and even more surprising, that the sentence states only that the parties to the dispute shall make every effort to enter into provisional arrangements of a practical nature pending settlement of the dispute. The absence of anything further in the new agreement is pointedly obvious because the language I just read to you is copied from paragraph 1 of Article 31 of the 1995 implementation agreement. But what was not copied is paragraph 2 of precisely the same article, which goes on to address the powers of courts and tribunals to prescribe provisional measures for conservation purposes. What's a court or tribunal to make of this? One hopes that the Article 5 requirement that the new agreement be interpreted and applied in a manner consistent with the law of the Sea Convention, together with the express incorporation by reference of the Convention's dispute settlement provisions, will save the day. And that's entirely possible. You can make a very decent legal argument to that effect. The absence of more detail on provisional measures is also interesting in light of the express authorization in Article 24 for the adoption of emergency measures by the Conference of the Parties to avert serious or irreversible harm to marine biological diversity. In this regard, we might recall that the Law of the Sea Convention contains elaborate provisions for settlement of disputes with the International Seabed Authority. But there are no comparable provisions in the new agreement for settling disputes that directly challenge actions that are taken by the institutions established by the new agreement. Following the pattern of other environmental treaties, the ultimate decision-making institution established by the agreement is in principle a one state, one vote organ. Now, that idea was clearly rejected at the time of the negotiation of the Law of the Sea Convention, which would have conferred such regulatory power on the Assembly of the Seabed Authority, but times and circumstances change. Should the same states that wouldn't have accepted that idea in the Law of the Sea Convention with respect to the Seabed Authority now be prepared to vest decision-making power in a new one state, one vote conference of the parties with respect to matters such as genetic resources, monetary and non-monetary sharing of benefits, and area-based constraints on existing and future activities. Now, to begin with, the arithmetic has changed. The new agreement, like the World Trade Organization agreement and the Biodiversity Convention practice, provides that where the member states of the European Union have transferred competence to the European Union can vote the votes of all the member states on matters within its competence, right? Now, that approach preserves the voting power of much of Europe on matters where competence has been transferred to the European Union. But that said, while I have no doubt that any one of you could draw relevant legal distinctions between the European Union and large federal states, it would still be interesting to be the proverbial fly on the wall, listening to how a politically accomplished US senator might try to explain to a puzzled constituent why the European Union should have 27 votes and the United States only 1. It's interesting in this connection that one of the many interpretations proffered by the United States in connection with the adoption of the text was its, and I quote, understanding that the Regional Economic Integration Organization, when voting on a matter within its competence, should only exercise a number of votes equal to the number of members who are present and duly accredited at the time of the vote. The implication, of course, is that the members present could have achieved the same or much the same result voting separately. Be that as it may, a thoughtful response to the basic question of entrusting decision-making power to the conference of parties requires, among other things, a careful reading of the text of the agreement. Viewed as a whole, the voting system in the agreement is not as reassuring as it might have been. The issue is not merely widespread numerical support, but widespread qualitative support that fairly represents all regions and all affected interests that are at stake in a particular decision. Now, from that perspective, a careful reading of the agreement may suggest possible arguments in favor of an affirmative response to the question I put. For example, the powers that are entrusted are circumscribed. Consensus is required for some decisions. There are a fair number of important substantive decisions that require a 3/4 vote rather than the ordinary 2/3 vote. Subsidiary organs will be established that may provide additional protection for affected interests. There is a right to opt out of certain decisions. And there are elaborate requirements for consultation with affected interests and with other competent international organizations, affording developing countries a reasonable stake in the benefits of development of genetic resources may secure a more hospitable climate for investment. The vetoes and consensus requirements can be used to block adoption of desirable environmental constraints. And the existence of a voting alternative may in fact facilitate the achievement of consensus. Those are just a few of the many points that could be made on the affirmative side. Such points and others, coupled with a candid assessment of the risks and other costs of joining and not joining, could form the basis for a conclusion that the benefits of the agreement outweigh the risks and other costs. In any such endeavor, it would be of more than passing importance that the advocates resist the temptation to overstate the benefits and thereby inadvertently magnify the risks. As Talleyrand counseled, surtout pas trop de zèle. Thank you very much. I'll be happy to deal with questions here or at the reception as I'll be told.
I think if we have a few questions and then we can do a few here and then we can head up. We invite everyone to join us up in the Goldberg room for reception.
Yes.
I was just wondering if there was any reason for avoiding discussion of the common law, public trust, and the notion of jus cogens in international law.
By avoiding discussion, you mean by me or by the negotiators or?
By you right now.
In what sense? I'm not sure.
History. Jurisprudential history.
Yes, of course you're correct. Of course you're correct. I left out far more than is included. There's just, you can't. That wasn't the object of the talk as I saw it. Maybe it should have been. I wouldn't quarrel with that.
Thank you. I really appreciate the elegant introduction to this agreement. My question is perhaps a naive one, but surely with the delegates to the convention that produced the agreement, these legal lapses in resolving what kinds of conflicts were likely to arise in the future were not because of lack of knowledge about what the agreements as written might entail and what conflicts might ensue. Was this done, was the reason for the drafting to make it more inclusive, to bring people along with the hopes that subsequent jurisprudence or subsequent agreements would resolve in favor of biodiversity these conflicts? Thank you.
Sure, absolutely. Any collective text, whether it's a statute or a treaty, is not going to be anybody's first preference. It's frequently not going to be elegantly drafted. It may even contain internal inconsistencies. and you do the best you can. This gets worse if you put it in negotiating setting because people don't want to play their last cards until they're sure it's all going to be over. In the case of this agreement, the final negotiation took 36 straight hours. And obviously, a whole bunch of things are going to happen in that concept. I learned this, by the way, early in my law school career when I was asked by the professor called on to comment on a particular statutory provision. And I said, quite frankly, professor, I tried very hard and I just cannot understand it. And the professor, to our amazement, leaned back. It's one of the security statutes of Adolf Berkeley. And he says, well, you know, it was 6 o'clock in the morning. President Roosevelt wanted the statute on his desk at 8 o'clock. And this was the best we could do. And I agree with you. It's not very good. So what can I say? Your point is very, very well taken. And I did not mean any of these points, as you can see from the conclusion. I just make them as possible that if I can stimulate some interpretive statements to cover those problems, that would be nice. I have no quarrel with the environmental objectives of this agreement.
Have a class coming in here shortly, so maybe we'll take the questions to the reception.